Today I'll be discussing on the topic role of the civil and the criminal courts. As we know you can say that there are two divisions of the courts. There may be a civil court and the criminal court, and there are more classification of the courts. Nowadays that there are special courts too. There are family courts too. And today we'll be discussing on the role of the civil and the criminal courts, and also we'll see the civil court structure and also the criminal court structure. So first and foremost, what is a civil court structure and what are the on which area you can say, or you can say which are the civil matters and which cases goes to the civil court. Now you see, disputes relating to property, breach of contract, wrongs committed in money transactions, minor omissions, etc. are categorized as civil wrongs, and it could be subjected to a civil process. In such civil suits should be instituted by the who will institute that. Now first you have seen that what are the disputes where or what are the matters for which we can approach to the civil code. The disputes which are relating to the property, the breach of contract, wrongs committed in the money transactions, minor omissions, they can be categorized as civil matters, and on this matters you can approach to the civil court. And who will institute the civil suit? And it should be instituted by the person who is aggrieved. And the court, it administers justice by considering the nature of the wrong done. And basically, you see, civil wrongs are redressed before civil courts by granting injunction or by payment of damages or compensation to the aggrieved party. This is you can see the fundamental difference between the civil court and the criminal court, you see. Where the civil court, it provides, compensation. What is a remedy available in the civil court? It may be a compensation or damages or injunction. But in the criminal courts, the one of the remedy is a punishment or imposition of fine. It may be, but there is most prominently the fundamental difference is that in case of criminal court there is the imposition of punishment which may be rigorous, which may be simple, but in civil court the one of the remedy available is it may be injunction, it may be most importantly you see that payment of damages or compensation, as we have studied, as you have all studied in the taught too. Now you see, as I have told you that what are the matters for which you can approach the civil code and who can institute a suit. The suit can be instituted by aggrieved person. Now where you will institute or file a suit, that suit should be instituted before the court of the lowest jurisdiction. Now the question is, which is the court of lowest jurisdiction? In the civil side, the munsif court is the court of the lowest jurisdiction. And see, if the value of the subject matter is worth rupees 1 lakh or below, the munsif court is the competent court to try the suit. Okay, if the value is 1 lakh or below, but if it exceeds above rupees of 1 lakh, the suit should be filed before the subordinate judges court, the sub court. An appeal from the decision of the munsif court, where it will go? It will be filed before the district court. So you see that the suit should be instituted before the court of lowest jurisdiction. In the civil side, who is the lowest jurisdiction? It's the munsif court. Now, if the matter is 1 lakh rupees or below, you will go to the munsif court, and if it exceeds more than that, it should be filed before the subordinate court. An appeal will go to it will be filed before the district court. Now, appeal from the decision of the sub court are filed before the district court if the subject matter of the suit is valued up to rupees 2 lakh. If the value is above now 2 lakh rupees, the appeal should be filed before the high court and the next to the Supreme Court. Now you see, first is the munsif court, then from the munsif court the appeal will be filed to the district court, and if it's like above 2 lakh rupees, then it will be filed before the high court, and next it is the hierarchy, the topmost court, and that is the Supreme Court. An appeal When it shall lie to the Supreme Court? It shall lie from any judgment, decree, or final order in a civil proceeding of a High Court in the territory of India if the High Court certifies that. See, it shall lie to the Supreme Court from any judgment. It may be from any judgment, decree, or order in a civil court, in a civil proceeding of a High Court. And most importantly, if the High Court certifies that. It involves the case, the matter, it involves a substantial question of law of general importance, and that in the opinion of the High Court, the said question needs to be decided by the Supreme Court. So it's very important that the case should involve a substantial question of law of general importance, and that in the opinion of the High Court, it needs to be decided by the Supreme Court. Okay, now see, judges, after going through the pleadings, oral arguments of the parties, it pronounces judgment or order. I have told you that when appeal lies to the High Court or the Supreme Court, it may be lying from where? From any judgment, order, or decree. But CPC, that is Code of Civil Procedure Code, it provides a clear distinction between the order, judgment, and decree. There is a difference between the three terms. These three are not same. Order, judgment, and decree. You have already studied it. But I am telling you that, again a revision, that there is a fundamental difference between the order, judgment, and decree, and it is clearly provided under CPC, that is Civil Procedure Code. Section 202 of the Civil Procedure Code, it defines the term decree as a formal expression of an adjudication which so far regards the court expressing it. It conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of the plaint and the determination of any question within Section 144, but shall not include any adjudication from which an appeal lies as an appeal from an order or any order of dismissal for default. There is an explanation to it. A decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of the suit. It may be partly preliminary and partly final. A decree must be drawn separately after a judgment. Next, you see how the CPC defines judgment. Section 2.9 of the CPC, it defines judgment as the statement given by the judge of the grounds of a decree or order. A distinction can be made between a decree and a judgment. It is not decree, judgment, and order one necessary for a judge to give us. This three terms is totally different. Section 2.9 of CPC, it defines a judgment as a statement given by the judges of the ground of a decree or order, and Section 33 of CPC, it defines an order as a formal expression of any decision of a civil court which is not a decree. In other words, the adjudication of a court which is not a decree is an order.